act normal, but act. And one of those acts should be consulting with whistleblower counsel who can navigate you through this perilous road, but it can be very economically lucrative if you do this in the right way.
If you know someone has been scamming the Medicare system and you want to blow the whistle, what's in it for you? Well, we're going to find out right now because that's what we're going to ask the lawyer. Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com. My guest is New Jersey-based attorney Jason Brown. Jason, good to see you again. Thank you for helping us out.
Good morning. Always great to see you.
So let's just start. Who are we talking about usually who would be committing Medicare fraud? Are we talking doctors, institutions, individuals? Help me out there a little.
Well, it could be the first two, doctors and institutions. Generally, individuals are not really, they could be committing Medicare fraud, but generally not addressed under the False Claims Act, because that's generally a private individual who's scamming the system. What the False Claims Act and the lofty whistleblower awards come from is when you blow the whistle on systemic Medicare fraud within the context of a constitution, some sort of entity like a hospital or pharmaceutical company.
And how do they determine it? I mean, the whistleblowers can get an award. How is that determined?
Well, each year, hundreds of millions of dollars go to whistleblowers who blow the whistle the right way, and hundreds of millions of headaches go to those that blow the whistle the wrong way. And part of that is determined by, number one, the success of the action. Do you prevail? So it's really important to understand before even commencing an action whether or not you have a case that's potentially winnable. Also, you look to the other C's. Candor. How candid is the individual blowing the whistle with the government? How long have they let the fraud go on before blowing the whistle? Another C, cooperation. The government, there's long periods of time after blowing the whistle in which you don't hear from the government. But when they want something, they want it right away. And they expect you to be cooperative. And another C is counsel. It's really critical to have an attorney that seamlessly interfaces with the federal government under the False Claims Act, which addresses Medicare fraud. And that's why my firm has had a lot of success in the past regarding cases based upon my background as a former FBI special agent and legal advisor.
And only thing I know about dealing with the government is it's always complicated. So having somebody who has experience with these kind of things makes a big difference too, right?
Oh, yeah, absolutely. I mean, we strongly encourage individuals who are contemplating blowing the whistle to consult with a firm that focuses its practice on whistleblower laws and protecting whistleblowers like we do. Even if it's not our firm, it generally is more effective if you have a firm that has a focus of their practice and has individuals who formerly worked for the federal government, because nothing's easy with the federal government.
So we're talking about awards, which is there's a monetary benefit to somebody blowing the whistle. Is there a percentage? Does it change? How does that work?
Well, under the False Claims Act, the percentages can vary. And one of the critical factors is whether or not the government intervenes or it doesn't. If the government intervenes, meaning that after the complaint is teed up to them, they decide they will be at the helm of the litigation, then generally a whistleblower is entitled up to 25% of whatever the government recovers. If the government doesn't intervene and the private firm like ours litigates the case, you can go up to 30%. But there's a little bit of a trade-off, because if you look at the numbers and the statistics over the years, generally when the government intervenes, the case value averages out to be about 13 million. If it doesn't, the average is about 3 million. So you'd certainly rather have 25% of the bigger number than 30% of the smaller number, but a win is a win is a win. So if you tee it up right, you still can walk away with a lot of money, because 30% of 3 million is still nearly $1 million.
So yeah, that's what I was going to say. So we're talking some pretty big dollar awards here.
It can be quite a big award for doing the right thing.
Are there some ways, some things you can do to maximize the amount of award you can get?
Yeah, I mean, certainly you want to blow the whistle early, because you're going to be graded on how long you let the fraud go on without you contacting the government. You need to stay on top of the action. What I mean by that is, with the right counsel, even though you don't hear from the government, your attorney should be reaching out for the government affirmatively saying, hey, is there anything you need? Also, for the right attorneys that understand how to successfully navigate whistleblower statutes, if you have information about corruption within the context of the company, oftentimes there's more than one cause of action, not just the False Claims Act for Medicare fraud or Medicaid fraud, but you may want to look for, like California, for example, has private insurance fraud statutes. Illinois, private insurance fraud. New York, tax fraud. You also have anti-money laundering statutes, IRS whistleblower, SEC whistleblower, CFTC whistleblower, and a whole bunch of other statutes. So when you have this opportunity and you have the information, you want to maximize your case. You really need to distill the fact pattern and find out all the possible avenues for recovery and take advantage of those.
What are some things whistleblowers should do and shouldn't do? Jason, what's your advice?
Well, they certainly should not take matters into their own hands. The saying is, don't be a cowboy or a cowgirl, because you don't know how to ride the horse. It's going to buck you and you're going to lose.
Right.
Under the False Claims Act by itself, you're not allowed to file without an attorney because the government doesn't want people making bad law. I always say this, but you should not contact the internal company reporting hotline, as anonymous as it may be. I watched a Simpsons episode the other day where somebody in that universe called the anonymous hotline, and Mr. Byrne came down a second later and goes, "You're fired." And similar conduct, maybe not quite as fast,
right,
will happen generally at the company where you have just set the machine in motion to get yourself fired. Also, surprisingly enough, you should not directly report it to the government without speaking with counsel first. Okay? Because the government, we have plenty of people who reported the matter to the government. The government ran with the matter. 5 years later, they read in the paper, government settled the case for $200 million. They want to know where their money is, but they may be entitled to zero because they did not blow the whistle in the right way. Wow. Certain things to do is to try to gather evidence at the direction of an individual, potentially counsel, to make sure your case is preserved, but don't go gathering evidence you're not supposed to normally have access to, because that can get you fired. HIPAA is interesting because there is materials protected by HIPAA, but there's exceptions for Medicare fraud. So you really need skilled advice in navigating that. And you should act normal, but act. And one of those acts should be consulting with whistleblower counsel who can navigate you through this perilous road, but it can be very economically lucrative if you do this in the right way.
What about retaliation? If somebody does blow the whistle, unless hopefully goes through the proper channels, contacts you, do they need to worry about retaliation?
Well, there's always a specter of retaliation that can manifest, but you have to remember, in the context of the False Claims Act, cases are filed confidentially under seal, where the defendant isn't even aware of it for several years, and the law firm that's handling the case should guide you regarding where your parachute is and what your options are when it finally becomes unsealed. And also, there's very strident protections under the H portion, is called, of the statute that entitle an individual who's retaliated against after the company becomes aware to double damages plus attorney fees and expenses. So really, the law really contemplates that if somebody does anything, the law's got your back in that context. And we do as well. We protect whistleblowers. I mean, that's our job. We admire individuals who have the courage to come forth with information, and we want to make sure they're protected at the end of the day.
We started off, you mentioned that your first determination is, does somebody even have a case? Most people may not even know how to tell whether they have a case or not. So is there any fee for contacting you, finding out, giving you information to even determine if they have a case to pursue?
There is no expense at all. We give people free confidential consultations. And there's subtle matters that make a case viable versus dead on arrival versus a $50,000 case versus a $50 million case, and information that individuals may not even know that they know. For example, Medicare fraud, inherently, if you're paying or your hospital or provider is paying kickbacks or finder fees for Medicare patients to be shepherded in their direction, that may be an inherent violation under the law, under the anti-kickback statute, that entitles the government to mega, really big damages, and you would also be entitled to a big relator share at the end of the day if successful. Also, if the hospital provider then refers patients to something else it owns without disclosing that, that could be something called a Stark Act violation because of self-dealing. So, yeah, you really need somebody who knows what they're doing to talk through what your facts are and to find out what, if anything, is actionable at the end of the day.
Finally, Jason, I don't know if you can answer this or not, but How big of an issue would you say? We're focusing on Medicare fraud. Is there a lot of that going on? Is it? I don't know. How do you know? What do you suspect?
Well, each year it seems to be $2 or $3 billion that are recaptured through the False Claims Act. But the attorney generals generally estimate that there's 10 times more than that going on. So $30 billion worth of fraud. Now, if we were able to successfully hit that, every single piece of fraud, and you do the math, even 20% of that is, I think, roughly $600 million for whistleblowers each year for doing the right thing.
And I guess the other thing to keep in mind, that fraud is against the government, and that's our taxpayer dollars that are being defrauded.
Yeah, at the end of the day, it ultimately hurts the taxpayer, and it hurts everybody. It strains the system, makes quality of care worse because people are doing it for the billing, not for the best patient interest. And it does. Everybody's mindful because they're thinking about a big tax increase is about to creep in, and we need to keep costs under control. And this is one way to keep costs under control.
I say it every time, Jason. It's always interesting. Very informative talk. Thank you for taking some time to answer our questions.
As always, thank you for having me.
That's going to do it for this episode of Ask the Lawyer. My guest has been New Jersey-based attorney Jason Brown. Remember, if you want the very best information or you like to be able to choose a lawyer that lawyers choose, make sure to go to AskTheLawyers.com. Thanks for watching, everybody. I'm Rob Rosenthal with Ask the Lawyers.